Welcome to this MBL webinar, Commercial Litigation in Scotland, Recent Case Law and Practical Implications. My name is Neil Morrison. I'm an advocate with Arnott Manderson Advocates in Edinburgh. So the learning objectives for today, the first thing we'll consider trends in Scottish commercial litigation. We'll then look at prescription and limitation issues. There are a number of slides on this issue. I won't address all of them, but you can certainly look at them at your leisure. We'll then turn on to the Scottish commercial case law and the influential English case law. And finally, we will consider the hot off the press Contract Formation and Remedies Scotland Act 2026. So, dealing with recent trends, I think across the board there has been increased procedural pragmatism and generally technical points being made are maybe the courts, in my view, less amenable to these types of points being made, pleading points, although there are, of course, some judges who will be more focused on pleading points than others. And there's been an expansion in group litigation, a huge number of group litigation cases now proceeding through not just the Court of Session, but also conjoined cases in the Sheriff Courts. There's been an increase, observation of mine is certainly an increase in the renewable energy disputes or disputes that are linked in some way to renewable energy, even if it's not a direct construction dispute or relating to a renewable energy project. There's also been a huge increase in the number of party litigants using AI and the issues that is causing, with the court having to grapple with sometimes cases and legal points that are not, in fact, accurate or indeed correct. There's also, I think, a greater scrutiny of contractual drafting coming through some of the cases. And of course, we have to touch on interpretation of contracts, what the recent trend is on that particular issue, given we are discussing commercial cases in this webinar. So, of course, there's the objective interpretation of the contract, strong emphasis on the contractual language with contextual and business common sense cross-checks. But a key point, and you'll see this in some of the case law I'm about to